International armed conflict and non-international armed conflict. Welcome to the second part of International Humanitarian Law for Public International Law by Dr. K. Sangeeta. Basis of International Humanitarian Law. Principle of distinction which applies in all armed conflicts. This principle obliges the parties to the conflict, warning the parties, whether the states or the non-state armed groups, to target only military objectives and not the civilian population or individual civilian or civilian object. Example: homes, schools, hospitals. Failing to make the distinction in the military operation represents an indiscriminable attack and is a war crime. Although it is not possible for parties to a conflict always to avoid civilian casualties when engaged in military operation, international humanitarian law also requires the parties to a conflict takes precaution in any attack to minimize the civilian deaths and injuries. Attacks likely to cause death or injuries among the civilian population or damage to civilian objects which would be excessive compared to the expected military advantage must be cancelled or suspended. International humanitarian law covers two areas: the protection of those who are not or no longer taking part in the fighting, restriction on the means of warfare, in particular weapon or the method of warfare such as military tactics. What restrictions are there on weapons and tactics? International humanitarian law prohibits all means and methods of warfare which fall or fail to discriminate between those taking part in the fighting and those such as civilians who are not, and the purpose being to protect the civilian population, individual civilians and civilian properties, cause superfluous injury and unnecessary suffering, cause severe or long-term damage to the environment. Humanitarian law has therefore banned the use of many weapons, including exploding bullets, chemical and biological weapons, binding laser weapons and anti-personnel mines. Connection between international humanitarian law and international criminal law. International humanitarian law and human rights law help to develop international criminal law. International humanitarian law and human rights law are also relevant for the interpretation and application. International criminal law is seen as an alternative when the states do not abide by their human rights obligation. Human rights law and international humanitarian law are connected, and it is applied in the international criminal courts of justice. The protection offered by the Human Rights Convention does not cease in case of armed conflict. It says through the effects of the provision for derogation and the kind to be found in Article 4 of the International Covenant on Civil and Political Rights. Armed conflict. The law and the custom of war or international humanitarian law were created to protect citizens during armed conflict. Under international criminal law, many violations of international humanitarian law are not considered war crimes. However, the two bodies of law have distinct modes of interpretation and application. While international humanitarian law can be useful in interpreting international criminal law, and the two should not be conflated. Prosecution of war criminals under international humanitarian law. On becoming party to the Geneva Convention, state undertake to enact any legislation necessary to punish person guilty of grave breaches of the convention. States are also bound to prosecute in their own courts any person suspect of having committed a grave breach of the convention, or to hand over that person over the judgment of another state. In other words, perpetrators of grave breaches, war criminals, must be prosecuted at all times and in all places. States are responsible for ensuring that this is done correctly. Prosecution of war criminals under international humanitarian law. States criminal law only to crimes committed on its territory or by its own nationals. International humanitarian law goes further in that it requires the state to seek out and punish any person who have committed a grave breach irrespective of his nationality or the place where the offense was committed. This principle of universal jurisdiction is essential to guarantee that the grave breaches are effectively repressed. Such prosecution may be brought either by the national court of the different states or by an international authority. In this connection, the International Criminal Tribunal for the former Yugoslavia and Rwanda were set up in the United Nations Security Council in the year 1933 and 1994 respectively, to try those accused of war crimes committed during the conflict in those countries. Categories of international crimes: aggression, genocide, crime against humanity, war crime, crime against United Nations personnel, mercenaries, torture, apartheid, slavery, pirating, aeroplane hijacking, illegal act against the environment, illegal drug trafficking, illegal pornography trafficking, theft on radioactive material, possession and use of illegal arms, illegal human experimentation, illegal act against maritime navigation, destruction and threat of national treasure, illegal act against internationally protected people, mail frauds, taking of civilian hostages, illegal act interfering with submarine cables, bribing public officials, forgery. When you see the core crimes, the four major core crimes are crime against humanity, war crimes, genocide and aggression. Now we will see war crime. There are no clear definition of international crime, nor is there any legal body that groups them together as such, in effect defining these crimes in a process of diversified codification by various treaties or by international custom. The international criminal contributes to international humanitarian law and international human rights law. Since it gathers advantages in codification and international custom, systemizes them and defines them in a single document, the statute of the code. Even after codifying crimes of genocide, certain difficulties in this determination remain. Crimes of genocide involve three fundamental elements: the identification of the group, the intention of partially or totally destroy the group, mens rea, and the commission of any of the acts mentioned in the definition, actus reus. The definition of group does not include political or cultural group. These categories were suppressed in the original version of the Statute of Rome due to strong opposition from certain sectors. In respect of mens rea and actus reus, the prosecutors must establish the criminal intent of the accused. The International Court on Tribunal on Rwanda and Yugoslavia has made important contribution to this concept. The Karasik and Ladik of the Yugoslavian, which was dissolved, the degree to which the group was destroyed in the whole or in a part, not necessary to conclude the genocide has occurred, that one of the act enumerated the definition was perpetrated with the specific intent which suffices. The intent which is peculiar to the crime of genocide need not be clearly expressed. The intent may be inferred from certain number of facts, such as general political doctrine which gave rise to the act possibly governed by the definition in Article 4 of the statute, or the repetition of destruction and discriminatory act. The intent may also be inferred from the perpetration of the act which violate or which the perpetrator themselves consider to violate the very foundation of the group act, which are not in themselves covered in the list of Article 4 subclause 2, which are committed as a part of the same pattern of the conduct. In August 1945, the Allied powers meeting in London signed the agreement that created International Military Tribunal, commonly known as the Nuremberg Court. Article 6 established that the tribunal would have jurisdiction to try those accused of crime against peace, war crimes, crime against humanity. Crime against humanity were understood as murder, extermination, enslavement, deportation and other inhuman acts committed against any civilian population before or during the war, persecution on political, racial or religious grounds, in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where it was perpetrated.